What you missed on the previous episode of Plugged In with Seeff Properties.
9 out of 10 times, it's best to always choose an executor who's not a beneficiary under the will.
How there are some aspects of the sale agreement that you actually you can't vouch for.
They would do their own inspections, and they would, describe the condition and the status of the property.
So I don't know if our viewers, I just want our viewers to understand what it means if you're buying a property and you're putting 2, 3, 5 million pula into Akheel Jenabaya Associates trust account, what that means for them.
Okay. So under the Legal Practitioners Act, and it has a lot to do with our the services that we provide. We usually act as what would be, in simple terms, the middleman. Because we protect, especially in the discipline of conveyancing, we protect, our mandate is to protect both parties' interests. So the trust account is an account that we open under the Legal Practitioners Act. We under extreme strict rules and regulations when it comes to the trust account. It gets audited every year. We have to submit audit reports to the Law Society, and essentially whatever money is in our trust account is not our money, and it's strictly regulated under the Legal Practitioners Act and the regulations. So, there's obviously been cases in Botswana where attorneys have unfortunately, misused their trust account. I don't want to go into that. That's something for the Law Society to handle. But yes, if you're dealing with a reputable law firm, the trust account is an account that is used as an escrow account. Okay. So the purpose for our discussion today, the purpose of a trust account is to ensure that there is a smooth exchange of assets. So what that means is that the seller will say, I'm not going to transfer my ownership of my property into your name unless the purchase price is secured. And the purchaser is saying that I'm not going to give you the money unless I get ownership. So if there's no middleman, the transaction's stuck. So that's the whole purpose of the attorney and his trust account. So you tell the purchaser, put the money in my trust account. I will not release the money to the seller until registration takes place. So the trust account is a means of facilitating the transaction between the seller and the buyer.
Great. And in general, what kind of advice would you want to give both sellers and buyers of property in terms of conveyancing and working with lawyers or attorneys?
Yeah, my advice would be, like any area of any specialty or any practice, like you wouldn't go to a heart surgeon for a kidney transplant, right? No. So there's a lot of lawyers that can do conveyancing, but they don't specialize in conveyancing. So I would advise the buyers and sellers to carefully pick their lawyers, carefully pick their agents that they use. And if you have a good lawyer on your side, or who's an admitted conveyancer, your transaction should go smoothly. The one thing that I would like to maybe use this opportunity to clarify is that with conveyancing transactions, there's always a question that the buyer and the seller has, especially the buyer. The buyer will say, I'm paying for the legal fees, so why should I use the seller's conveyancer? The reason, so there's no written law that states that the conveyancer must be chosen by the seller. But the reason why the common law, let me say the practice is that the seller chooses the conveyancer is because, okay, let me give you a typical example. Let's say you are a buyer, you selling me a property, and I say to you, Dabilo, I want to use my conveyancer, but you the seller. And I, as the buyer, put the purchase price into my attorney's trust account, right? And you transfer the property into my name.
I have no control.
You've got no control. So I'm acting for the purchaser.
Yeah.
And if I squander all that money, you've lost your property. You don't
Yeah.
have your purchase price. You see, so that's the main reason why the sellers always choose. You know, that's the reason why if you go to developers like Pakalani Estates, Time Projects, they will always select who the conveyancers are because they are giving ownership of their assets. So they want to ensure that their interests are protected. They've got more to lose than the purchaser. Because naturally, on the reverse side, if the purchaser puts the money, and this is very important for purchasers to understand. So if I, as the purchaser, put my purchase price into your conveyancer's trust account, and your conveyancer decides to go on holiday with that money, I'll say to you, Dabilo, that's not my problem.
Sure.
I want ownership of my property. You told me to use that conveyancer.
Sure.
So I want ownership of my property. You will sue your conveyancer. That doesn't become my problem.
Yeah.
But where the purchaser chooses the conveyancer, you see the difference in terms of the potential losses if the seller does agree to the purchaser.
But there are exceptions, like for example, where the purchaser says, I do want to buy your house, Akheel, and ordinarily I'd use your conveyancer as the seller, but I also have to sell a house to raise money for this transaction. And my conveyancer is doing my sale. So can my conveyancer do both my sale and my purchase of yours simultaneously? Is that an exception that could be accepted?
Okay, so what happens is when it comes to those type of transactions, remember as law firms as well, we can link our transactions together.
Right.
So if you're selling your house and your sale is dependent on your acquisition from my client who's the seller. So what happens is that you'll say to me, I'm using law firm A, and then my law firm will get in touch with law firm A and say to him, look, we need to link our transactions because your sale should not happen prior to or after my sale. They should both happen at the same time.
Right.
So from a transactional point of view, the law firms can link the transaction. And when you say link, that means that at the deeds office, one transaction cannot be registered without the other. They have to be registered simultaneously. And that's also a very big aspect of protecting the parties. You know, if sale 1 has to be linked to sale 2, where you'll say that, look, if I don't get sale 2, I don't want sale 1 to go through. So what we normally do is we link our transactions and we make it a simultaneous transaction. And then from the purchase price point of view, like, you know, all law firms have got relationships with other law firms. And we usually comfortable in accepting letters of undertaking from, you know, our from other law firms as well. So, like, for example, I can write a letter of undertaking. I can tell another law firm to say, I've got my client's money in trust. I will issue you with a letter of undertaking. It's like a bank guarantee, but obviously from a law firm, that I will pay you the purchase price upon these transactions being registered. Accepting my letter of undertaking is purely the decision of the lawyer as well as the client. So, you know, if you're my client, I'll say to you, no, I know that law firm, don't worry, it's fine. But, you know, sometimes you might not be comfortable and say, no, look, I've had a bad experience with that law firm. I don't want that undertaking. So then that law firm there is a way of getting a bank guarantee. You know, we can use the funds in our trust account in order to ask our bank to pledge those funds and for the bank to give you a guarantee. So they fix the funds and issue a guarantee.
One last question I just want to ask about registering property in a buyer's name. Can two people, because people have arrangements now where, say they're in a relationship which is not a marriage, but they're obviously forward thinking and they're doing very well, they're young and their careers are going well and they want to buy a house together. Would you be able to register two unrelated people?
Yes.
on one property. Can they buy a house together in this in here?
Yeah, so it's you can register a property in favor of as many people as you want.
Right.
You can have 1,000 owners of one property.
Right.
So, and then also in terms of the share in that asset, you can have an agreement that stipulates what percentage of the property you have, but usually it's always stated as in equal and undivided shares.
Right.
So you are both, in that instance, so a couple like that would be, the partnership that they have in terms of the law, it's called universal partnership.
Okay.
Where they're living as husband and wife, but they're not married.
Yeah.
And they're acquiring assets together, and they're jointly developing themselves.
Yeah.
But they're not married under the laws. So that's what they've created is a universal partnership. So they can acquire the asset together, they can register it. So they'll be joint owners.
And when it falls apart, if it falls apart, what they can do is
Then
sell the property.
it becomes a commercial transaction.
They
So
can sell
one can buy out the other, or they sell and they divide.
Right.
Yeah.
Okay.
So yeah, I think that's basically it. In the other point that I wanted to mention in terms of the buyer and seller, in terms of a lot of the arguments that start coming out of that, is also in relation to the interests that the buyer has. I mean, the buyer, like whoever selects the lawyer, like for example, if you select me, then your buyer will feel that I'm going to look after your interest. So I just wanted to mention that there's nothing stopping the buyer from choosing his own attorney to oversee the transaction.
Okay.
Yeah. So like it's called a watching brief or an over.
Okay.
So you can have your attorney, and then the purchaser can appoint a different attorney, and the two attorneys will work on looking after the parties' interest, and then ensure that the transaction runs smoothly. So it doesn't mean it will cost you a little bit extra, but obviously your interests will be protected.
Okay. I think that brings us to the end of our discussion, Akheel.
That's good. Thank you very much.
I really enjoyed it. I have a few more questions, but I don't want to go on all day. I think maybe just finally, freehold land, state land, tribal land. I know it's a big discussion. I know it's very broad, but just in short, how they differ.
So, freehold land is okay. All these are referred to as land tenures. That means the nature of the property tenure in terms of how the property is held. So freehold is land that the government has got no interest in. Tribal land is land that's owned by the tribe of a specific area, but it's and managed by the land board through the Tribal Land Act. State land is land owned by the government, and owned by the government, and a person who has state land has got the right to use the land. So essentially, the major difference, I think in the most simplest way to explain it, is that freehold land is owned by you and your successors in, I always get this word, it's always a tongue twister for me,
Perpetuity.
Yeah, that word, right? Yeah, exactly. And then a state grant and tribal land, they've got fixed periods within which which the person, the grantee, has got the right to use that property. So you'll find that in most residential state land and tribal land leases, it's 50 years. I'm sorry, 99 years.
Yeah.
Most commercial and industrial would be 50 years. So for that period, you've got the right to use the property. The other major thing to point out is that with tribal land and leasehold property, if your lease from the land board is not registered, or your certificate from the land board is not converted into a lease and registered. So there's going to be a time when the Tribal Land Act amendment comes in, where certificates of customary grant can be registered. So basically the biggest difference of leasehold property is that if you have a lease that's in your name, and if it's not registered, what that means is that you've got a personal right against the lessor. in terms of your enforcement of your interests with respect to that lease. The moment you register it at the deeds office, your right converts into a real right, which is now enforceable against the whole world.
Okay.
So if there's the difference between this is that if there's a third party that comes and says, hold on, I've also got a lease. If your lease is registered, subject to obviously the legalities around it, you find that your right is much more superior than a third party's rights with respect to that land. That's the reason why banks will only accept registered title as security, because they want their mortgage bonds registered, because it's now enforceable against the whole world.
Right. Okay. Wow, great. Thanks, Akheel. Like I said, we could talk for ages.
Yes.
I mean, I haven't seen you in a very long time, and I know I always have questions for you in terms of, what happens in the legal world with property. But I think we're going to stop it there for today. Thank you all for watching, and look out for the next session with Plugged In with Seeff Properties.